I think in the early years, it's not clear how free exercise was understood or how broadly it was understood. The history of persecution, especially in Europe, but also in some of the colonies here, in Massachusetts, in Connecticut, in Virginia, everyone agreed that was a bad thing. Right? So it seems clear that at least they were agreed that free exercise protected the right to believe whatever you wanted, to hold church services, to preach, without any sort of special permission from the government. And that's never been disputed, and free exercise still clearly protects those things today. What is much more of an issue in our time than it was at the beginning is whether free exercise of religion protects acts of conscience or religiously motivated conduct. And they talked about that a little bit. They didn't talk about it much because it really was not an issue in their time, right? The country was overwhelmingly Protestant, probably more than 99%. So there were liturgical differences and theological differences, but there were very few differences about moral values or right behavior. And there was much less government regulation. So there were many fewer conflicts between religious practice and government regulation. And so the ones that arose could be handled one at a time. The Quakers, over a period of years, but mostly by the time of the French and Indian War of 1755, were exempted from serving in the military. The first of those statutes is Rhode Island in 1673. They were exempted from swearing oaths, and that was pretty much everywhere by the early 18th century. In the colonies that still had church taxes, one by one the dissenters were exempted from paying those taxes. There were a couple of colonies that had a statute that said if it was against your religion, you did not have to remove your hat in court. That sounds like kind of a silly thing, but there was a famous incident involving William Penn, who had deliberately left his hat outside the courtroom so he wouldn't be ordered to remove it for the judge. The judge had the bailiff put the hat on his head and then ordered William Penn to remove it. So what I infer from those is when they thought about it, when there was a conflict between a religious practice and a law, and the religious practice could be exempted with no serious harm being done, the response was to exempt it. And people who are more suspicious of protecting religious behavior say, well, yes, but that was all by legislation. They didn't understand the free exercise clause to protect those things. Well, this is colonial America. The free exercise clause as such didn't exist yet. Judicial review didn't exist yet. I think those exemptions tell us what that generation thought religious freedom entailed. Beginning in, to some extent, in the 20s, in the wake of World War I, and accelerating in the 40s and continuing after World War II, the Supreme Court became much more interested in enforcing individual liberty across the board. And the free speech clause went first, was developed first. And then the race discrimination cases began in that same era, with the court striking down various forms of discrimination. And then free exercise of religion followed the path of free speech. And they said from 1937 to 1952, the Jehovah's Witnesses had 25 cases in the Supreme Court. And they won like 22 or 23 of them. They were mostly speech cases, but they were religious speech cases. And the court talked about free speech and free exercise as preferred freedoms that got special protection. And it was in this period that they began talking about what became the modern test of strict scrutiny and compelling government interest, that government can interfere with a constitutional right only for the most compelling reasons. And all of that came together in 1963 in a case called Sherbert versus Verner. It was from South Carolina. Adele Sherbert was a Seventh-day Adventist. She lost her job in a textile mill because she would not work on Saturday. And the state, and she didn't sue to get her job back. There was no law in those days against religious discrimination in employment. She applied for unemployment compensation, and the state refused because they said she was not available for work. And the Supreme Court said, you have to accept sincere religious reasons for not being available for work. And to take away her unemployment compensation is equivalent to fining her by the same amount for refusing to work on her Sabbath. And then there was another case in 1972, Wisconsin versus Yoder, about requiring the Amish to send their children to high school. And the Amish sent their children to public school through 8th grade, but then in high school they would have had to send them into town at a much larger school and many more non-Amish people. And they refused to do that, and they said, we're engaged in vocational education on the farm. It's not, in a sense, it's the first homeschool case, right? And I think that was 8-1. The court said, the Amish are entitled to an exemption unless Wisconsin has a compelling interest in requiring them to send their children to high school, and Wisconsin only requires another year and a half to age 16. How much difference is that going to make? That's not a compelling interest. So that was the law basically for a generation, from 1963 to 1990. And then in 1990, without being asked, the court reversed field in a very dramatic but also very ambiguous way in a case called Employment Division versus Smith. There's a long-standing religious practice among American Indians. The anthropologists believe it goes back thousands of years, in which peyote is used in a worship service. In some ways it's analogous to communion, but it's different because they take doses big enough to have an effect, right? And they believe they directly experience the presence of God while they are under the influence of the peyote. It is protected by federal law. It was not in those days protected against state law. And actually, this is another unemployment compensation cases. These two guys, this sounds like something a law professor made up for a law school exam. These two guys worked as drug counselors in a state drug abuse agency. One of them was Native American, one of them was not. Neither had been practicing this religion. They both went to a service of the Native American church, consumed peyote, and made the mistake of telling their supervisor about it, and got fired. And the state insisted it had a no exception policy for any form of alcohol or drug. If they'd taken a Catholic communion, they would have been fired as well. I don't believe that for a minute, but that's what the state said. And again, they applied for unemployment compensation and were denied. And Scalia wrote the opinion for 4 conservatives plus Justice Stevens, and it said, if a law is neutral and generally applicable, it can be applied to a worship service or to any other exercise of religion. No special justification required. Free exercise of religion does not require exemptions from generally applicable laws. He never explained what he meant by a generally applicable law. The ban on peyote clearly was. There were no exceptions of any kind. Nobody could use peyote. And a lot of people viewed that as sort of a repeal of the free exercise clause. But there were many, many ambiguities in that opinion. And at one point he said, actually at a couple points, if a law has a secular exception for the same activity in a non-religious context, then there has to be a religious exception as well. And some of us said, that's most laws. Laws have all kinds of exceptions. That's how legislative deals get done. In the immediate wake of Smith, there was a bipartisan reaction. This is wrong. Congress should protect the free exercise of religion by statute, and that was passed essentially unanimously, with Democrats and Republicans together. The ACLU and the National Association of Evangelicals together. It was a left-right secular religious coalition. And the Supreme Court upheld that or assumed it was okay with respect to federal law, but struck it down as applied to state law. So now most cases against the federal government proceed under that statute. Cases against state and local governments still have to proceed under Employment Division versus Smith, but now the conservative majority is interpreting Smith very aggressively to say, if you got any kind of exception at all, you got to have a religious exception. And 4 of them have said explicitly they want to overrule Smith. And 2 others have said, well, Smith looks like it was wrong, but we don't know what to replace it with, so let's go slow here. I think we're about to see another change in law. So the Supreme Court has been back and forth over the last 60 years. It's the best we can do. James Madison said, if men were angels, we wouldn't need government. But men are not angels, and now we have to figure out how to control the people who run the government. And judges do not always do this well. They do it better than legislators. Actually for several reasons, but maybe the most basic is they're required to pay attention. Someone files a case in court, the other side files an answer, the judge has to entertain that case and take it seriously. And judges actually show up for court hearings, and each side has an advocate to marshal the evidence, and the judge listens to all that. Maybe there's a jury with him, maybe there isn't. The judge listens to the arguments, and he has to render a reasoned decision that he explains in an opinion. If you write your congressman and say, the government's impinging on my religious liberty, I got a problem here, he is not required to pay any attention. He doesn't have to answer. Maybe some staffer will take an interest in this issue, or maybe not. They don't show up for hearings, or they wander in and out. I've testified at congressional hearings, and there are 15 seats up there, and 8 of them are occupied, and people come in, people leave, and they hear part of it, and they don't hear the rest of it. They're extraordinarily busy. They're dealing with literally hundreds of legislative issues, plus all the fundraising, plus the campaigning, plus all the constituent service. And they are very subject to political pressure, right? And so the religions most in need of protection, because they're so unpopular, can never be protected by the legislature, because their constituents who are doing the persecuting would rise up against the congressman. Back in 92 or so, this is in the wake of Smith, Congress, in the course of passing the Religious Freedom Restoration Act to try to override Smith, there was a case pending in the Supreme Court about an Afro-Caribbean group in South Florida that sacrifices small animals. And Hialeah had banned it. And the sponsor of the Religious Freedom Restoration Act sent out a Dear Colleague letter to all the other members about a congressional friend of the court brief. He could not get a single office to even talk to him about it, because who wanted to be on the side of sacrificing these small animals? The Supreme Court found that to be basically a case of persecution. This group had been singled out, and unanimously, 9-0, they said it was protected by the Free Exercise Clause. So that's a fairly dramatic example, but no congressman could afford politically to try to protect that group. And the one guy who wrote the letter was in a very safe district and maybe didn't think it through all the way. But the courts, which are appointed for life and don't have to worry about constituents, were able to do the right thing. Now, they don't always do the right thing, right? They're subject to public opinion as well. They come in with worldviews that clash, and they have rights they like and rights they don't like, so it's a very imperfect system, but better judges than legislators. And I will also say sometimes legislators are willing to protect when judges aren't. A pretty effective way to get legislative attention is to lose a case in the Supreme Court because it generates a lot of publicity. So, there was a case back in the 80s. The government wanted to build a road through the High Sierra for logging purposes, connecting two dead-end roads. And Native Americans sued and said, this area was sacred to their religion. They used it for meditation, and the noise of logging trucks and so forth would completely disrupt and prevent that. They sued under the Free Exercise Clause. The Supreme Court said wasn't protected. And actually, a lot of people don't like this opinion. I think it's actually kind of plausible. But basically it was, we stole the land fair and square 100 years ago, and now it's government land and they can manage it however they want to. And Congress responded with legislation, killed the road. And there's several other examples like that. There was an Air Force captain who was forbidden to wear, he was a psychiatrist on a stateside air base, forbidden to wear his yarmulke in uniform. He lost 5-4 in the Supreme Court, and Congress passed a statute to fix the problem. So there are examples like that. And then there are also examples where some religious group gets the ear of Congress and gets a bill passed, or a state legislature, that goes way too far protecting some religious practice that really is harmful and that no judge would ever protect. So, 46 states at one point had laws saying if you object to having your kid vaccinated before he goes to school, either religiously or a lot of them said, or just a personal philosophical objection, he doesn't have to be vaccinated. Until the recent craziness about COVID, no judge had ever said anything remotely like that. And I think 5 of those states have now repealed those statutes. But that's a case of legislative protection going too far, and it's a flip of the other problem, right? We only listened to one side. This time it was the religious side that got our ear, and we never heard or paid attention to the other side. The Supreme Court has repeatedly said over the years the standard is compelling government interest. They've paraphrased that in various ways. They haven't given anything that is really like a definition or a standard. And they've never explained where it comes from. It's like they just made it up, right? The First Amendment is written in absolute terms, right? Congress shall make no law abridging free speech or prohibiting free exercise of religion. Well, it turns out you can't literally live with no law, right? If I'm urging the mob to burn down your house, I'm speaking, but we really have to be able to regulate that. So my view has always been the compelling interest exception is implied by necessity, right? When it's absolutely essential to regulate something, even though it's a constitutional right, that's when we can do it. The Supreme Court has never said that. It just said there's a compelling interest exception. They haven't volunteered to tell us where it came from. That may be more a theoretical issue for law professors than for the public, but then there's the issue of what interests are compelling. Well, physical, tangible harm to somebody else is generally a compelling interest. That's pretty easy. The hard cases about which we often disagree are the cases where the harm is intangible and where often, it's just lots of people are deeply offended by you doing this. But if you think about it, they're not really affected. Or they're affected in pretty marginal ways. So, if you think about the current round of cases on same-sex weddings and people in the wedding business, right? The plaintiffs in the Denver case that went to the Supreme Court immediately got a free cake from another bakery, right? As soon as the publicity began. They didn't lose anything tangible, but they say, we suffered dignitary harm. We were terribly upset and offended when you refused to serve us, and some of them say, and when we know the reason you refused to serve us is you think we're immoral, right? We're insulted. Well, that's a real harm. I get that. I don't think it's a compelling government interest to prevent that harm. And if you compare that harm to the harm on the other side, the baker is harmed permanently. They're harmed in a one-off incident. But the baker has to either permanently surrender his conscience and agree to do a same-sex wedding whenever someone asks, or he has to surrender his business and his occupation. Baker in that case gave up 40% of his business and laid off half his employees because he didn't make wedding cakes anymore. So, I don't think that's a compelling interest at all, but lots of judges do. I don't think the current Supreme Court will, but the Supreme Court of 30 years ago very well might have. And so on questions like that, you do get answers that depend on the predilections of the judges. And that's a problem in the system. It's probably not a problem that we can eliminate, right? It's just there because the government is still run by humans. Judges are the most insulated, independent officials we have, and we do better giving the problem to them than giving it to the legislature, which is subject to all kinds of pressure from both sides and will generally act on much less information. I don't want to take away judicial power. I think it's essential to protecting individual rights. They are influenced by public opinion. If they feel strongly, they'll resist that influence, but they feel that. I think some of them feel the court as an institution has only so much credibility, only so many chips it can play, and what fights are worth taking on, what fights are not. And in the long run, if the people feel strongly about something and persist in that opinion, they will elect presidents and senators who will appoint and confirm new judges who will eventually change the rule. The best known example from roughly 1890 to 1937, the Supreme Court aggressively reviewed economic regulation. And they upheld some of it, they struck down a lot of it, and they sort of had reasons for regulating the economy that they accepted as legitimate and reasons that they didn't. And it was partly about freedom of contract, it was partly about limiting the role of the federal government as opposed to the states. And it became a crisis in the Depression when Roosevelt's trying to reinvigorate the economy, and they struck down a lot of what he was doing. And then in 1937, Justice Roberts changed his mind, and they upheld some key legislation. And then, other justices who were getting older retired. So in Roosevelt's first term, he got no appointments to the Supreme Court. By the end of his third term, I think he'd appointed 8, and Truman got the 9th shortly thereafter. And the magnitude of the change you can capture in 1936, they said coal mining is not in interstate commerce. Congress cannot regulate coal mining. And by 1942, this is only 6 years, they said a farmer feeding his own wheat to his own hogs affects interstate commerce by reducing the supply and can be regulated by Congress. So, when the court gets far enough out of line with what voters want, eventually it's brought back into line through new appointments. And in the shorter run, it's sometimes influenced by fears of public reaction and public opinion. So yeah, they're still human. They're still, to some extent, within the political process. All we can say is you're more likely to get a detached and neutral ruling from a judge than from someone who has to run for re-election. We teach our children that we are committed to liberty and justice for all. I recite that every day for 12 years in most school districts, right? That's what individual liberties are about. And we protect unpopular speakers because we understand free speech to be very important to the people who want to say things and ultimately important to the political process. And Justice Holmes said, it's most important we protect the speech we hate. I'm not sure the public believes that to the same extent we once did. I think most lawyers believe that. I think lots of people believe that. Precisely because you really deeply disagree with it, you're over tempted to censor it, and that speaker's individual right to free speech is just as important as yours. And free exercise is the same way. We seem less inclined to protect the religions we disagree with. But we protect it in part because it is terribly important to those who are devout believers. It causes immense human suffering to try to force them to change their religious practices. We protect it to keep the social peace, and we forget how much of the reason many of these disputes now seem kind of marginal is because the promise of religious liberty has been so successful, right? So religious liberty is invented in response to the wars of religion. A third of Europe died in the 30 Years' War, 1618 to 48, and it's mostly Protestants versus Catholics. And the great Protestant powers aligned against the great Catholic powers. Lots of people died in the English Civil War, which was also over. It's partly about the king and parliament, but it was very much about Puritans versus Anglicans and Presbyterians. And some of that came to America in the early years, right? Quakers were hanged in Massachusetts. They were whipped through the towns to the state border in Massachusetts. Preachers were jailed in Virginia for preaching without a license. And so the guarantee of religious liberty in the First Amendment is very much in response to that history. It was very fresh to the framers. It's a long ways back to us. And they guaranteed two things, right? The federal government will not interfere with your own exercise of religion and will not attempt to establish some religion of its own that will inevitably get in the way of yours and interfere with yours. And even if they try to establish your religion, they wind up interfering because they're so clumsy and it's such a different kind of organization. And the Civil War extended the Bill of Rights to the states, but most of the states had already provided similar provisions in their own constitutions. And those have been highly successful in the sense that most of the worst abuses haven't happened again in a long time. I mean, they happen occasionally, right? The governor of Missouri issued an extermination order. Mormons must leave or be killed in the 1840s. The reason Jehovah's Witnesses had 25 cases in 15 years in the Supreme Court was that city governments all over the country were trying to exclude them and shut them down. There was bitter Protestant Catholic conflict through the 19th century and into the early 20th century. There were churches burned to the ground. There were mobs and people killed in the streets over religious disagreement, right? And it's a wonderful thing that things like that hardly ever happen here anymore, right? They still happen in places around the world. They don't happen here. And so, for the liberty of individual conscience, for the reduction of social conflict, for the reduction of human suffering, I think it's very important that we protect the free exercise of religion, and that we protect against the establishment of religion, right? I would not let government take positions on religion or encourage people to be more religious or less religious. Supreme Court increasingly disagrees with me on this, but I won't let them put up crosses or Ten Commandments monuments. All that should be in the private sector and not done by government, and it certainly shouldn't be pushed on children in the public schools. And I think the 30% of who say they have no religion, some of them mean they're not attached to an organized religion. They actually have kind of conventional religious views. But most of them, they're either non-believers or they just view religion as irrelevant. They don't think about it. They are also protected, right? They don't worry very much about government coming down on them, in part because they are not taking moral teachings from a scripture that's 2,000 or 4,000 years old, so they're less likely to have conflicts with the majority viewpoints that drive government policy. But they can also be interfered with in places, right? And we've got a strongly religious local majority. So I think the free exercise and establishment clauses are a pair. They're not in conflict. They both protect religious liberty for all of us. And what we think about religious liberty should be independent of what we think about religion. That is, the whole idea of religious liberty is we all agree to leave each other alone in this realm and respect each other's liberty with respect to religious matters. And so it doesn't matter which side of this multi-sided divide you're on. You have an interest in protecting everybody, including the people you disagree with. Because if you don't protect the people you disagree with, you're not really protecting anybody, right? The people the majority agrees with don't need any protection. It's always the people we disagree with that have to invoke their constitutional rights. Think about Northern Ireland, right? They were killing each other for 30 years. And then they somehow negotiated a peace and agreed to leave each other alone. And it's not at all, they still hate each other as best I can tell, right? But they're not killing each other. And they're running a government somewhat cooperatively. One side is refusing to sit in Parliament at the moment. So that conflict's not over, but it's no longer deadly, right? And they're doing so much better than they were. And we think of that as a political settlement, and it was, but part of it was the two religious sides agreed to do much more towards leaving each other alone. And if you think about the countries where religious liberty is narrowest, you think about non-Muslims in Muslim countries. Some Muslim countries are tolerant and some are extremely intolerant, right? And it's a capital offense in some countries to convert away from Islam. I think they would be much better off with free exercise. There would be less human suffering among those who were persecuted. I think they would also be more likely to make economic progress. And there are studies of that. Economic success and religious freedom are correlated. It means that on these, to my mind, unanswerable questions about, is there a God? What does God want of us? Where do we learn what God wants of us? That every American can believe whatever he wants, whatever he finds most persuasive or most believable. And I think that right is absolute. And the Supreme Court has said it's absolute. And that to the maximum extent possible, we can act on those beliefs. And the government will interfere and regulate religious practices only to serve a truly compelling interest. that involves some kind of tangible harm to other people, and not trivial, something substantial, right? We all inconvenience each other for religious reasons and other reasons, right? Every day. When I go to the grocery store, I aggravate the traffic problem. So, and there are people who think they have a right to regulate the shade of white paint on their neighbor's house. So we have learned to claim that everything that we don't like is harmful. So that can't be the standard. When there's some substantial and tangible harm to others, then the government has to step in and regulate. But that, to the maximum extent feasible, government should not influence what we believe about religion. It should neither encourage nor discourage beliefs or practices of religion. I really do believe that the Free Exercise Clause and the Establishment Clause are partners that are equally important in protecting the religious liberty for all of us, and that we should enforce the one as aggressively as we enforce the other. And not many people believe that. I mean, too many Americans think free exercise is pro-religion, establishment is anti-religion, and I want to pick the cause that's on my side. If I'm religious, it's all free exercise and get rid of the establishment. And if I'm secular, it's all establishment and get rid of the free exercise. No. They both keep the government out of the way. They both leave religious choice and commitments as much to the individual and the organizations he chooses to join as possible. So I would emphasize both.